here by Ms. Crane. I just left you a stern message on your phone.
With a bill for pizza?
No, Mr. Skowronek already owes us that.
Okay.
Let's see. Well, I think the other person who came in at the same time had already been here and got kicked off somehow. All right. Before I swear in, all we got here.
I think that's her that's shown as P.E. Smith C on there, to be honest with you, Your Honor. That's who I suspect is the mother.
Oh, I thought she was with DFAX.
I don't know who that is.
You need to unmute your mic and tell us who you are.
Okay, can you hear me now?
Yes, ma'am.
Select a speaker. Wait a minute. Select a speaker, select a microphone, microphone array. Microphone array is your microphone. There you go. Click it. Click it.
You don't
Can you hear me now?
Yes.
Where's your volume turned up? Where's the volume button, baby? The volume's not up. The volume is on the side on this. No. Jesus, man.
We can hear you.
Let me see. Volume is off. You just clicked it off. Yeah, it just clicked off. Oh, jeez. Okay, hang on. All right, what did you do the last time with the unmute, mute, and unmute?
You're unmuted, but you may not. Are you hearing us? Obviously not. Unless.
Now, where's the volume control, baby? This right here.
A weekend already. He's kind of tight-lipped. So I don't know too much about him. I don't know if he plans on staying in town or not.
Ezekiel Cain is the name God gave me.
Okay. So we'd ask for a suspended sentence with an obey all laws clause, Your Honor.
All right. Thank you, Mr. Puentes. Mr. Payne, anything you would like to say before I sentence you? You're not required to say anything, but you are welcome to, sir.
Ezekiel Cain was the name God gave me.
All right. So, Mr. Payne, you're starting to concern me with regard to what you're saying. Do you understand everything that's happening this morning?
Yeah.
Okay.
I'm in jail.
Do you know where you are right now, sir?
I'm in a courthouse.
Okay. Do you know where you are within that courthouse? Do you know where you actually are physically this morning?
Reno Par.
Okay. And do you have any questions about anything that I've gone over with you this morning thus far?
Am I going to get my knife back?
Welcome back to Time Served, the channel that scans the docket so you don't have to. I'm Phil, and today on the docket we have a general theme going on. Probation violators all getting cuffed in the courtroom or after their Zoom appearance being told to report today. Bad mamas, bad liars, even worse excuses. One after another, our judges called them out on their BS and gave them a free vacation courtesy of the state. This woman does not have it her way. Live from Subway, Judge DeSanto is not hearing it. She said her vodka was spiked with vodka. I don't know, you be the judge on that one. This bad mama is a repeat offender in Judge Shackelford's courtroom, and she's had enough. Judge Boyd scares this mama's boy straight. Judge Washington was back from her vacation, and boy, did she have a docket, one after another, and I think there was a boob slippage. And finally, you won't believe the allegations you hear in Friend of the Court, Brian Nicholas's courtroom, where there's allegations of half-naked men, abuse with brooms, drugs, and 4 funerals. That's all I'm saying. And before we get into the clips, all these violators only had 2 drinks. Not 1, not 5, 2 drinks, maybe 3. But 2 drinks seems to be the built-in excuse. Don't forget to hit that like and subscribe, set your notifications to all, and never miss these bad mamas. Court is now in session. Let's roll, nerds.
Okay, and my phone with the hair in the ponytail, please unmute. Is that Ms. Duvall?
Yes, I can barely hear you.
Is your name Jill Duvall?
Yes, it is.
Okay. If you're having technical issues, ma'am, you have to come into court. You have to make your way into court. So if you can't hear me, make sure that you're adjusting your volume accordingly.
I can't hear you.
Then you need to come into court. Can you hear that?
Need to come to court?
Ma'am, you need to adjust your volume or adjust your device, or you will have to make your way into court.
I have volume up all the way. It's just like you're far away.
And what?
It's very far away.
Okay, so then you can make your way into court.
Well, I'm about 4 minutes away.
I'm sorry?
I'm sorry?
I'm sorry, where are you at?
County.
I can't understand you, ma'am.
I'm in Monroe.
Monroe County. Well,
Okay.
is there another device that you can log in on, ma'am? Because your connection is not great. Mr. Ball,
Are you talking to me?
I am. Is there another device that you can log in on because your connection is not sufficient for court?
Is there another phone I log in? Yes.
What is that?
Are you asking me is there a phone I could log in on?
Do you have another computer, some other device that you can log in on?
I got somebody else here that has another phone.
What is that? Mr. Ball?
I'm trying to see. Who's calling? Zoom. I'm gonna turn on you. It is turned on. How do you do that?
What, Mr. Ball, I cannot hear what you're saying. And quite honestly, you're taking up court time trying to figure this out. So you need to log in on another device.
I'm in a courthouse.
Okay, do you know where you are?
Good afternoon, Your Honor. Christopher Shemke, appearing on behalf of my client. At this time, we've sent to the matter being heard via Zoom.
Okay, thank you. All right, and ma'am, Ms. Solomon, please unmute and state your name for the record.
Tanya Solomon.
All right, and so today's the date scheduled for probation violation. You're currently on probation for operating while visibly impaired, and it's alleged you failed to appear for drug testing on July 15th, test positive for alcohol July 17th and July 30th, and you were sentenced in this court on June 28th. So all within the first 30 days, there's 3 violations. And counsel?
Your Honor, I've had an opportunity to review this matter with my client. She will not be requesting a violation of probation hearing.
Ma'am, please raise your right hand. Do you solemnly swear from the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. And so, counsel. I'm sorry, Ms. Solomon, you heard the allegations that were placed on the record, correct?
Yes.
And as to those allegations, how do you plead?
Guilty.
And you've gone over your advice or rights for probation violation purposes, correct?
Yes.
And as to those allegations, how do you plead?
Guilty.
Well, I'm sorry. You understand by entering into a plea that you'll be waiving some of those rights that you've already gone over, specifically your right to a contested hearing.
Yes.
And you also understand the possible penalties as a result of your plea, correct?
Yes, Your Honor.
Specifically, the recommendation here is for you to continue your probation, pay a $50 probation violation fee, increase your testing, and 15 days jail. Do you understand that?
Yes.
And that recommendation is based upon your sentencing order that was there was mandatory jail for any violation. Do you understand that?
Yes.
And knowing all that, you still want to continue with your plea?
Guilty.
Okay. Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
All right. And counsel, if you can please run your claim.
Yes, I'd like to direct your attention back to July 15th. Did you fail to take a test as ordered by probation? It's a drug test on July 15th, 2023. Yes or no?
Yes.
All right. And then a test that you took on July 17th, it indicated the use of alcohol. Is that accurate?
Yes.
And then the test that you took on July 30th of 2023 that indicated the use of alcohol. Is that correct?
Yes.
Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. And the court will accept your plea to the probation violation, indicate technical violations 1, 2, and 3 will enter, and counsel asks for the recommendation.
Your Honor, I've had an opportunity to review the recommendation. I saw that there's a recommendation for increased testing. I saw that there was a recommendation for jail to have no review. I would be respectfully requesting consideration for there to be a review date on that. She indicates that she will comply with any and all terms, conditions, that she will have no further missteps, and that she will make sure that there are no issues with probation going forward. Thank you, Judge.
Okay, well, so, ma'am, you weren't even on probation
Yes.
for 3 weeks. You failed to appear for your drug test July 15th. Why didn't you appear for your drug test?
Because I was with a guy and he put something in my drink, and that's the reason why I had broke up with him, and I'm done with him because I pay in the court so much money. I'm not trying to mess my life up. I'm not trying to go to jail. I work, I got my own house, and I'm not trying to lose everything. So I had to get rid of him. So I'm done with that. I'm trying to get my life together. I'm in counselor right now. I'm doing my counselor and stuff. So I'm just trying to be on track, you know.
Okay, can you please stop walking around, ma'am?
Okay.
So I'm sorry. What, so you didn't appear because you knew you were going to test positive?
Excuse me?
So you didn't appear because you knew you were going to test positive?
No, I did not. I didn't have a ride to work. I know I could get in a lift and stuff, but I ain't had the money at that time because I'm paying the court. I was riding a bike. It's like 4 miles away from my house, but my bike got on flat. So now I got my bike fixed. So ain't nothing to be worried about. I'm gonna be on time going to my testing. You know, I'm doing my counseling, whatever the court needs me to do, I want to do. I want to be on the right track, not, you know, on the backwards. I want to go forward. So I had to leave a man alone that made me, he told me he gonna put me in jail. He put liquor in my drink when I was drinking, and I turned out positive, you know. So I didn't know to my probation officer.
Ma'am, hold on.
Uh-huh.
When did the person put something in your drink?
Yes, my boyfriend, he an alcoholic. And he drink. So he put something in my drink. I didn't know till my probation officer told me that I violated. When she told me, I was shocked. You know, I don't do things like that. I'm trying to get myself together. I've been paying the court, and you know, I'm not trying to mess my life up.
So ma'am, what were you drinking that he
I don't even know what
added alcohol to?
I don't know. Because he said he gonna lock me up. I'm going to jail. Oh, you gonna go to jail. I don't know what he put in my drink. I don't know. But he wanted me to go to jail. That's what he told me. Oh, you gonna go to jail. I didn't believe it to my probation. My probation said you violated and you've been drinking too. I'm drinking. You know, I've been going testing all this time and I ain't had no drink in my system, you know? For these 2 days, I had drink in my system. So I was shocked.
Ma'am,
Mhm.
pause. You just testified under oath that you tested positive on July 17th because your boyfriend put something in your drink.
Yeah.
So what is it you were drinking that he added alcohol to?
He drank vodka. I don't know what he had. What did he drink? I don't know what he poured in my
No, I'm
drink.
asking no, ma'am, you're not listening to what I'm saying, please.
Uh-huh.
You are telling this court that your boyfriend put something in your drink. What were you drinking? What were you drinking? Or what did you think you were drinking before he put something in your drink?
He drank vodka, so
no, I don't care what he drinks. I'm asking you, what were you drinking that day?
Vodka.
You were drinking vodka. Okay. And so on July 30th, what were you drinking?
Same thing, vodka.
Okay. And why are you drinking vodka, ma'am?
I didn't know that he did that to me.
No, stop blaming it on somebody else and take accountability for your own actions, because you know what a vodka drink tastes like. So why were you drinking vodka on those 2 occasions, ma'am?
Your Honor, I don't know.
You know, ma'am, that if you violate, it's mandatory jail. I told you that at your sentencing.
Yes.
And you went ahead and you consumed alcohol, not just once, but twice.
Yes, Your Honor. It ain't gonna happen again. I had to just
it for sure won't happen for the next 15 days because you're going to be in the Wayne County Jail. Ma'am, you have an issue with alcohol. You had a prior in 2008. Then you have this one. And this is a .26. A .26. And then you violated now twice by consuming alcohol. And then you're trying to blame it on somebody else as to why you're testing positive for alcohol. You're in court today. What?
I didn't know he did that to me. He made some Kool-Aid. He said he was gonna put me in jail. That's what he said. He gonna put me in jail when my probation officer. Yes.
Ma'am, your levels would suggest that you had more than 1 sip of the Kool-Aid, the vodka spiked Kool-Aid, if that's what I'm supposed to believe. So what I'm telling you, ma'am, is you know what vodka tastes like.
Yes, Your Honor.
You know what it feels like after you consume vodka. So don't try putting it off on somebody else if they spiked your drink. You're responsible for that. You consumed it. You could taste it and you could feel that you consumed vodka. The sooner you start taking accountability for your own issues and actions, the sooner you can potentially be on the path to recovery. The court's adopting the recommendation. You're continuing to complete all terms of probation, pay a $15 probation violation fee, you're going to serve 15 days jail starting today, and increased testing upon your release. So you're going to email into Ms. Shaw, and she'll tell you where you need to report today by 6 p.m.
Okay, Your Honor.
Anything else?
Nothing else, Your Honor.
No, Your Honor.
All right, thank you.
because you exercise that right. You understand that?
Yes.
And you understand you have a right to be proven innocent or to be presumed innocent until you're proven guilty by a preponderance of the evidence. It's a probation violation hearing, so that's 51%. You understand that?
Yes, ma'am.
You also have a right to call witnesses to speak for you at trial or at the hearing, and I would sign a subpoena to get them here if that was needed. You understand that?
Yes, ma'am.
All right. The allegation, Ms. Miller, is that you tested positive for alcohol and had a PBT at 0.07 on August 9th at 9 a.m. And you tested positive for alcohol and had a PBT of 0.06 on August 9th at 9:04 a.m. And that you admitted to drinking on August 8th. How do you plead?
Guilty.
And you understand you'd be waiving the right to the hearing if I accept that plea. There will be no hearing of any kind.
Yes, ma'am.
All right, I'm going to accept the plea as knowing and voluntarily given.
Your Honor, what I'm going to say to the court is not an excuse for her conduct, but just want the court to know it's something that apparently is beyond her control. On the day of the incident, or the day prior to being tested, her daughter was rushed into the hospital for surgery. That was just another straw on the camel's back. She reports in the last 2 months she's been trying to evict her boyfriend or ex-boyfriend from her house, because of his negative conduct. She's facing a foreclosure. Everything's just been overwhelming on her. She doesn't want to be, or she's asking the court if the court would reconsider about removing her from the sobriety court. She realizes she does need help. She was in rehab last fall and seemed to be doing very well until the end of May, when all these problems started multiplying and she had the trouble of coping with it. Yeah, her 93 days in jail. I'm asking the court to reconsider that. Maybe some sort of rehab program would help her out better. That's all we can say, Your Honor. It's not like a deliberate violation where, some people come into this court and they don't have any reason. They just decided they want to drink.
Yeah.
She's got situations she can't cope with, and she needs some sort of guidance and help, and begging the court for it, Your Honor.
Here's the problem with Miss Miller, and this is very difficult. This is a tough hearing for everybody in the room right now, or at least her and I and Miss Hagner. Miss Miller has this case back from 2021. She was originally on standard probation, and she kept drinking on standard probation. She'd never been in trouble before, so that was indicative to everybody involved in the case that she probably needed an elevated level of treatment. So she was brought into treatment court. When she was brought into treatment court, she continued. We had her in an IOP, which was a level of care that the therapist thought was appropriate, and she started escalating. She was not just using alcohol, she started using crack. So then we did everything we could right away, and everything I am saying is true, and you know it. We did everything we could right away to get her better treatment. She got a bed in Naomi's Nest, and went to Naomi's Nest for inpatient residential treatment. She was in for how long, Ms. Haver?
45 days.
Yeah, it was a long, it wasn't like she was in for 7 days for detox. She stayed in 45 days. She came out, she was gonna hit the ground running. When did she get out, Ms. Haver?
It was sometime in January that she went immediately into IOP.
Yeah, and then we got her immediately into IOP. So she's now done 45 days inpatient, second bout of IOP. She's learning all of these coping skills. That's what they go there for, right? You're learning all of these different ways that you can react to stressful situations or triggering situations besides use. We got her into peer recovery. She was in IOP. She continued to use. She finished IOP the second time, and then went to standard, right? She was just seeing her therapist every week, going to group every week, right, Kelsey? Correct me when I'm wrong. And then she started using crack again.
Cocaine, yes.
Well,
Yep.
okay. And then she had a violation for that in May. She didn't show up for testing in June. She missed IOP in July. She had 2 positive cocaine tests in May after completing a second round of IOP.
Yes, this was within a month of completing, and at that time we put her back into IOP again.
So she's now in her third round of IOP. So she's currently in treatment 3 days a week, plus she sees her own therapist, right?
Once a week, correct?
Once a week. Do you go to that group once a week too?
Yeah.
Yeah, okay. You see Sarah still?
Yes.
So she's got a peer recovery coach. You go to her meeting?
Yes.
And you go to AA a couple times a week. So, I mean, other than jail, there's nothing else I can do for Miss Miller. Miss Miller doesn't, we just heard this lady speak at Families Against Narcotics, at an event, this opioid awareness month. Beaumont put something on. What was her name? Tiffany Jenkins. And she's in recovery, and she talked about being in recovery, and she said she did 2 inpatient stints. The first one she did it because the government told her she had to avoid jail. And she went through the motions, she did what she had to do, and she got out. The second time she did it, she had completely hit rock bottom, and she knew she needed to change. And that's when she quit using. And Miss Miller, I don't know where rock bottom is, but she's not in this program. It's clear to me she's not using any of the resources we've thrown at her because she just continues to have use violations. She has all of these tools, all of these people she could call. She knows she could come sit in the court if she wanted to. She could call Kelsey. She could call her peer recovery coach. She could call her therapist. She could call one of the 15 girls in our peer group, in the women's group that I know she has relationships with. And she could have done all of these things. She could have went to a meeting. She could have used all of these tools, and instead she decided to use, and then she came to court drunk, knowing full well she's still drunk from the night before.
Yeah. That could be another cry for help. I know that a lecture that you heard, the lady went 2 times to IOP. This may be her rock bottom, and it'd be a shame to give up hope and to throw her in jail, just throwing her to the wolves. Also, Your Honor, if I could just mention, if the court is going to incarcerate her, if she can have a startup date. She's got 2 minor children at home, and the child's father is finally doing something. He never supported him, but he's filing for custody. So she does have to make arrangements for those 2 minor children.
Yeah, the problem is with keeping her in any capacity is we don't have time. She's got to have, we have phases in the program. She's in phase 2.
Right.
So she just had a violation. So now it'd be 90 days without a violation before she could go to phase 3. And then she's supposed to do how long in phase 3, Ms. Havner?
Minimum of 3 months.
A minimum of 3 months. And so that altogether is 6 months that we need. And how long do we have her?
Until January 5th, so about 5 months.
We don't have time for her to graduate. We don't have time for her to finish the program.
And if they're successful during that time, they'll be well worth it, though.
And that 90 days is also a guarantee that there is no further violations or use violations. So it's not even a guarantee to advance within 90 days.
I know I'm not actively involved in sobriety court, but my understanding is incarceration for long terms really does not help in addiction.
It doesn't, but neither does keep helping and helping and helping someone who doesn't want help. At some point, it's like I'm just screaming off a mountaintop. She's not listening. She's not taking advantage of any of the resources. I just don't see the point in it. And it's heartbreaking and it's so sad. And Miss Miller's been with us for a long time, and it's like we start to see her make progress and then she reverts right back. And she's reverted right back to the point where I don't know if I can keep her. And I don't think she's expecting this. I think she thought she could use, and it was going to be like all the other times. But now time's running out. And if she's not learned anything yet, I don't know that she's going to.
Yes, I mean, that's kind of where I'm at, Judge. I mean, you know, they say incarceration is not gonna help, but clearly recovery is not helping her either. She did reach out to her peer recovery coach that day, but she didn't even talk to her about wanting to use or about to use. So, I mean, if she's not gonna take the step further to tell people, hey, I'm at my rock bottom, this is what's going on, I don't see how much else we can help her if she's not utilizing her tools to the best of her ability.
Your Honor, today's not an eye-opener for Ms. Miller. Nothing would be. And the court still has time to keep her in the program. And, you know, down the road, you know, 2 weeks, 3 weeks, you can still throw her in jail for 90 days.
Ms. Havner, didn't she just do 5 days in county on her last violation?
She did 4 days, Judge.
In Wayne County Jail. Look at little Miss Miller. She, if 4 days in Wayne County Jail, and then how long she been in now?
5. So she did 4 days in Wayne County Jail in May, and the same day that she came out, she used cocaine.
She used.
I'm sorry, it was 2.5 days I was there.
Okay, so 2.5 days later and she got right out and used, so that didn't work. And then she's been in for 4 or 5 days now.
That sort of supports the argument that the jail doesn't help in addiction.
Yeah, what, right, but neither does therapy in Miss Miller's case or any of the other tools we're giving her, because she keeps using anyway.
She had a couple months there where she was sober and no violations.
I mean, when we're 18 months along and she's still not using her resources, I mean, that's very alarming.
Yeah, I mean, at this point, these should be proximate goals. Like these should be things that she's able to do. I don't know, Miss Miller, I can't see any.
I did put the minor children's father on the consent form, so I can call him following this hearing and arrange contact.
You'll love that.
For the children, so the children will be fine.
This
The other 2 are adult children.
I'm sorry. It's an individual who barely supported the children, and now he's trying to seize on his opportunity.
It is what it is.
It is what you made it.
Yes.
It is, it's
Yes.
what you made
Yes,
it,
Your Honor.
Miss Miller. This isn't, it is what it is.
No.
This is your reality because you created
Yes,
this
ma'am.
reality.
I apologize for saying that.
I mean, this is, you know, is it good for the kids, for the ma to be, you know, doing crack and coke and
No.
drinking when she's looking at all this jail time? These are rhetorical questions. I mean, we all know the answer. All right, I'm gonna call this other matter. Miss Miller can just sit for a minute. We'll call this other matter real quick. That's according to the guidance center. Like they can't think of anything else other than 3 stints in IOP and a residential that would help Miss Miller, you know, learn some coping mechanisms or deal with whatever trauma she has, you know, and this is still her first response, even with everything that we've provided. I'm gonna give her some credit for the time she's been in the program. I'm sorry, Kelsey, I lost your paper. Ms. Miller, you can still do this on your own when you're ready. If you continue down this path, I'm confident I'll see you again. What?
I don't want to be like that anymore.
All right. I'm gonna give her 80 days. Credit.
Startup date?
11. No, start now. I'm sorry, Miss Miller. This one was, you knew better. And then on the jail, what's that? I gave her 80, credit 11. and I need the jail paperwork. Who does the jail?
Just very briefly.
Okay.
Can I speak on that, Your Honor?
After
On
your
the bond
attorney, after your attorney gets an opportunity to review the report and give you advice as to whether you should speak or not. He specifically needs to address the whole, I don't have money growing out my A. I hate to sound vulgar, but it is what it is. Part of this report.
Yeah.
Yes, Your Honor.
Yeah.
Certainly, Miss Jackson's words that were alleged if that were inappropriate. That said, at this time, we'd be pleading guilty to the bond violation with an explanation.
All right, ma'am, you understand you have a right to have a hearing in this matter whereby if it is found that you did violate the terms of your bond could be revoked. It's my understanding you're choosing to waive your right to have that bond hearing and you're going to admit to the violation. Is that correct?
Yes, Your Honor.
Please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. You may lower your hand. Ma'am, is it true that you failed to test like you were ordered to do?
Yes.
Thank you. I find that there's a knowing and willing admission to the bond violation. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
LeBeau?
Yes, Your Honor.
Thank you. Ms. Jackson, what is your
Can I-
explanation for that, and especially for what you said? Well, first of all, did you said that?
Yes.
Okay.
I'm being 110%. I did say that. It was after she had repeated over, and one thing about me is I don't like when people like have to, I'm grown, I'm an adult. You don't have to explain things as if I'm a child. And she was doing that. And I was telling her, like, not trying to be vulgar or anything, but I don't have money. I recently just applied to a store around the corner from me and they just hired me. So hopefully soon I'll be able to get some money. And I did say over and over to her that I do not have a way there. I do not have a job. So even if I was to go test, I don't have a way there and I don't have a way back. And I multiple times explained it to multiple people that that was the case. And before it even got to me even being vulgar, I had explained to her in the nicest way I could possibly say it, I don't have money right now. Even if I did have money, I don't have a way to community corrections and I don't have a way back home.
You're right.
So hopefully with the upcoming, I start Wednesday with the new job. So hopefully I'll be able to have some sort of being able to test. I have not smoked any weed since I found out I had the warrant. Since the arraignment, I haven't smoked. So I've been doing pretty good on that. Everything else I'm doing good at is just the testing. That's kind of the only thing I haven't done.
All right. Well, I appreciate your honesty.
Mm-hmm.
Is there an allegation of substance use in this particular case, Ms. McDuffie?
There is, Your Honor. It involved definitely alcohol use. I'm not sure if there was any other substances involved, but alcohol was at the center of it.
Your Honor, I see no allegation the police report of any substance other than alcohol.
Ma'am, here's the problem. I appreciate your honesty, but the reality is we're not going to wait for another 2 weeks for you to get a paycheck for you to test.
I understand that, Your Honor. And if I had the ability to pay today, I would even walk up there. But I don't have it. I don't have family members who are willing to give it to me. I don't have any resources to get it. That's why I was kind of waiting to this moment so I can explain it to you and at least get some sort of leniency. I know we're adjourning this case. I know by the date of the next case, I would have tested.
Ms. McDuffie?
Your Honor, I'll leave it in the court's discretion. And I also understand that Ms. Jackson might be frustrated with the repeated warnings, but I think that the point of that was to impress upon her, and she may understand that as well, that the alternative is to be denied bond and be in custody. So obviously, I think she would want to avoid that. So I'll leave it up to the court.
Anything you want to say, Mr. LeBeau?
Yes, Your Honor. I believe it would be appropriate for the court to simply order Ms. Jackson to test by her next court date, given that the alternative would essentially be her being incarcerated for being unable to pay for testing.
How long are you requesting for your adjournment?
Just briefly, Your Honor, we need to review some body cameras, so 1 or 2 weeks.
I'll put this over to August 28, 2023 at 9 a.m. You to do an ETG test by then, ma'am. If you haven't done it by
So
then,
that's just the standard P test.
no. Well, you pee in a cup, but they're testing for alcohol.
I have a question. Did they say I was drinking?
Yes,
I
you
don't drink. I think that's the one thing that's confusing me. Only thing I was like weed. I wasn't.
Ms. Jackson, stop talking, please. You should give our office a call and we can explain. We can go over the police report to you in further detail if you'd like more information about what's going on. But please do not make any more statements in court.
Confusing. That is very confusing. Okay.
All right. Definitive test by the time she comes back here, or then we will have a warrant situation. So if you don't test by then, ma'am, I will be issuing a warrant. You need to test. August 28th at 9 a.m. We'll see you then. The court will call the case of Rayshawn Dawson. State your name. Terica Jackson. While we wait for, all right, this is scheduled for a bond violation hearing today.
That's correct, Your Honor. At our last pretrial, unfortunately, Ms. Jackson had just logged off before we were able to address the violation report that we had at that time. And so we received an updated report that's essentially the same, which is that Ms. Jackson, we don't have any record of testing results for her. I know that at one point we had discussed her potentially testing at a location in Inkster, but I don't know if there's just a release of information that needs to be completed or where we are with that.
Ms. Jackson, did you unmute? Oh, there you are.
Yes.
Could you state your name?
Terica Jackson. Ms. Jackson, it's dark where you are. I cannot see you, ma'am. Could you please turn on some light? Yeah, got it. All right, thank you.
With regard to the violation, it's my understanding that Ms. Jackson's going through some hardships and has not been able to make it to the testing center. And I know she wanted to speak to the court on that. My understanding is that she was also just recently evicted from an apartment complex or an apartment. And she wanted to elaborate on that.
So the way it works is she either needs to request a hearing or admit to the violation or admit with an explanation, but
I
just
think
to-
at this point, I did speak with her and she would admit to the violation.
Time.
With an explanation.
And to further testify, defendant has not attempted to contact he or the party's minor children since that date.
We just addressed this on June 5th, but okay. Ms. Jackson, it's my understanding that
so I'm
you
going
wish
to
to
continue
waive your right
placement.
to have a hearing with respect to the bond violation.
I'm just reiterating what I'm
admit
saying.
to the
And then
violation.
two,
Is that true?
a defendant should be
You
awarded.
admit to the violation, your bond can be revoked. You understand? All right. Please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, ma'am.
Thank you. You may lower your hand. Ma'am, is it true that you just have not tested at all since this started?
Yes.
Mhm. I find that there's a knowing and willing admission to the violation. Are you satisfied, Ms. McDuff?
Yes, Your Honor.
Okay. Mr. Jokis?
I'm satisfied, Your Honor.
All right. The explanation.
Ms. Jackson, can you let the judge know what happened with the eviction? Your explanation on why you haven't tested.
Oh, I mean, I'm having a hard time with money, a hard time with transportation. I just got a lot going on. The time when you moved it to Inkster, I went down there twice and my information wasn't there. I did attempt to go. I spoke to a woman named Stephanie. If it was to go closer, I could go, but that's just way too far for me right now.
Ms. Jackson, if the court were to order you to go test today, is that something that you could do at community corrections, which could then transfer this to Inkster?
No, that's too far. I have no way of getting there. The first time they did it, I didn't have to go to community corrections. They just ordered me to call and speak with the probation department, and that person gave me the number and name and place I needed to test at. So I don't understand why would I have to come that far now.
Ms. McDuffie?
So, Your Honor, as the court mentioned, we did actually essentially have the same discussion on June 5th. At that time, Ms. Jackson indicated that it was too far, that she had some other court issues she was trying to work out, I believe in Dearborn Heights, and she was trying to coordinate testing with that and asked about Inkster. So at that time, I believe that we had, the court gave her permission to test at a different location, but she needed to coordinate that. So I guess I'm not really clear when she said that she spoke to a woman named Stephanie in Inkster. Is she saying that she attempted to test in Inkster and for some reason they didn't have an order, or I guess I'm not really clear on.
Yes, they said that they didn't have, they said, because it was a Friday, they said since, like give it a couple hours, but they were closing. They didn't have my information over yet. Try to come, the next day. So I went the next day and the same thing happened. She said the information hadn't been switched over yet. So I don't know. Either way, I went to I called the probation officer like you guys said do. The probation department gave me the information to my nearest testing site and I went from there, but they didn't have my information available so that I was able to test.
All right.
What DJ?
Ms. McDuffie, anything further from you?
No, Your Honor, if it's just a simple matter of a new order that needs to be submitted, then the people don't have an objection to her beginning. But it obviously needs to happen somewhere. So as long as it starts happening, it's fine with the people.
Ma'am, you to report within 48 hours for testing. If there's no testing at this time, then the next time will be a bench warrant.
So do I just call the probation department like I did? Would you make an order or however you did it the very first time, where I just have to get released to another city? That's exactly what I did. I did not have to go to community corrections.
Your Honor, I can assist with transferring that order if I get a hold of it. I can also speak with someone over in probation over in, I believe, in Inkster.
I don't know if that's the way it works. You can speak.
No, I spoke to the probation at where you guys are. 14B, I called there after court and they instructed me how to get to the nearest one to me. They were supposed to be sending something over. I don't know what happened. But if I have to go to community corrections, I might as well get a warrant right now because I'm not going to be able to make it there. It's too far.
You will speak to Mr. Drukas, the probation department here in 14B. If you speak to them, I'm sure they'll get whatever documentation over to Inkster.
Okay.
If she does not test within the next 48 hours, a bench warrant will issue, as she just indicated. We currently have final settlement conference scheduled for September 28th and a jury selection for
Yes.
what's the October November 6th? No, October.
I see October.
Too far.
Okay.
Oh.
Hello, how are you doing today?
Good, and you?
Oh, I'm doing great. Why do you think you're here?
For compliance hearing for coming out positive.
All right. And what else?
That should be it.
Well, let me just tell you the report I'm receiving on you. All right, and this is what the probation officer is saying to me about you. And how old are you?
20.
All right, you're 20. Since obtaining the probationer's case, when they say probationer, they're talking about you. He has shown zero to very minimal effort regarding his probation. The probationer has had issues reporting on time, reporting for field visits, testing positive for cocaine and meth, and enrolling or providing proof of employment for any remaining court-ordered programs. The probationer and I have had several discussions regarding his actions and how or what we can do to get back on track, really stressing the small actions, such as simply calling this probation officer within 24 hours after an attempted field visit, or taking accountability for his action. The probationer appears to continue to struggle to grasp the severity of his circumstances and what he can do to grow and move forward with his life, and the lessons he can learn on his probation path. That's the report that I have on you. The report tells me you are doing nothing, zero, nada. Why are you doing nothing on this probation in this court other than using drugs?
I have attended 2 out of the 4 classes, and we have had.
No, they say you don't even call in.
Probably when they come for a field visit.
Yeah, they say you're not doing the simplest of things. And what I can tell you is you've had 3 motions to revoke in this court. So, and I know that each time you came before me, I've told you that you're looking at up to 10 years in the prison. Deputy Laura, could you do me a favor? Could you place the handcuffs on him, please? Each time you come before me, I know I've told you you're looking at doing 10 years in prison. Obviously, your mother is not laying down the law with you at home. They say that you keep saying that you work with your mom, but you don't provide any proof. I can tell you right now, I'm not going to allow you to work with your mom because I don't know if your mom is actually having you work with her. So you're going to ISF. And the reason why I'm sending you to ISF is because you need an attitude adjustment. You understand? Now, if you don't want to sign to go to ISF, you don't have to sign for it. What will end up happening is a motion to revoke will be filed. So which would you prefer?
ISF, Your Honor.
All right. So he wants to go to ISF, and if you could put him in ISF cognitive.
Your Honor, so we, the recommendation was for local ISF.
Okay.
He did complete the state ISF.
Okay.
Are you?
Well, if the recommendation is local, we can go with the local.
Okay.
Has he been drug tested?
He's on a drug patch, Your Honor.
All right. All right. So you're going to go to local ISF. This is the last time we're going to have this conversation with you following rules. Obviously, your mom is not laying down the law with you. So you're not going to be allowed to work with your mom. You're going to have to get a job with a different employer, because if you get a job with a different employer, that employer, if you don't report, they're not going to pay you. They're not going to call the court and say, oh yeah, he reported for work if you did not. Do you understand?
Yes, Your Honor.
All right. Do you want to go to prison?
No, Your Honor.
All right. If you want to go to prison, I will get an attorney appointed to you and you can go to prison and I'll send you to prison. How old are you?
20 years old.
All right. You're 20. You're going to have to start doing better. Do you have children?
No.
That's a good thing. Probation, this is serious. And I hope I'm getting your attention, because we're not going to have a conversation again where you're not doing anything. You understand?
Yes, Your Honor.
Now, is there anything else you need to be successful on this probation?
No, it shouldn't be.
All right. Do not come back here again where you are not doing anything. You understand?
Yes, Your Honor.
I keep an open mind on everything, but we are not going to have any more compliance hearings with you. If I get a report and it appears that everything is in order, a motion to revoke is going to be filed. When a motion to revoke is filed, what ends up happening is a warrant is issued for your arrest, and you will be picked up wherever you may be. You could be at the grocery store in the middle of checking out or have already checked out. You know what's going to happen? Those groceries are going to be put to the side and they're going to take you to jail. If you are at home, they're going to pick you up and take you to jail. If you're in the middle of watching a movie and you're at the part where they're about to solve everything, guess what? If they pick you up during that time, you're going to miss what happens. Do you understand?
Yes, Your Honor.
In this court, probation is serious. In this court, communication is key. And probation officers know that I like for them to communicate with people. And that's why they put in here that they've had several discussions with you regarding your actions. Do you understand?
Yes, Your Honor.
All right. Good luck to you.
Thank you.
Good morning. This is referee Brian Nicholas from the Macomb County Family Court. And ma'am, your name for the record?
Amanda Ashton.
All right. Good morning, ma'am. Please realize this is a remote hearing, but even though it's remote, it's a hearing, even though as if you were present in the courtroom. This is a legal proceeding. Do you have any questions regarding that, ma'am?
No, Your Honor.
All right. And ma'am, do you know that this was scheduled for 9 o'clock and we're now at approximately 9:40? So you're 40 minutes late here for this hearing.
Correct, and that's my apologies, Your Honor. I was on the phone with the main branch of the friend of the court trying to get the hearing info, and I was getting redirected, and they couldn't.
Can you tell me your phone number? Because we left you a message last week, my staff, with all of the information and sent you an email. What's your phone number?
It's 586-843-6034.
That's the phone number that we have that we left the message for with the information regarding the hearing today.
Well, I was
Do you
also
got
out of
no-
town. I was
Okay,
out
when
of
did you
town,
come
Your
back
Honor.
from
I
out of
had,
town?
a couple of days ago, I actually had 3 deaths in the family. A friend of mine.
And who? Okay. And
my
who all died? Who passed away? I'm sorry.
a good friend of mine, my ex-sister-in-law, which would be my ex-husband's brother's baby mother, and then my uncle.
Okay. All right. So, ma'am, I've been speaking to Mr. Kaziaka and his attorney. Did you receive a copy of the motion and the allegations that were made in that motion? Have you received a copy of that motion
Yes, I
from
do.
Mr. Kaziaka? Have you had an opportunity to read through that?
Yes.
All right. And just so you know, I'm going to go fairly quickly because I have other hearings waiting, and therefore timeliness is important when you have a motion. So, but I'm going to take for granted that you had connection issues and didn't have the information, even though our records show we sent it to you. So I'm going to review those allegations and the conversation I've had with Mr. Kaziak and his attorney, and they're going to correct me if I get anything wrong about that conversation. So it's alleged that in mid-July, there was a physical altercation between you and your boyfriend. Your daughter got involved. He struck your daughter. She threw a broom and hit him in the head, causing bleeding. That other individuals in the home had to remove him because of the volatility of that incident. That on more than one occasion, different male guests in your home have been in different states of undress from the waist down, and another one pleasuring himself in the living room in the presence of your 11-year-old daughter. That the house is unsanitary, has animal feces, is filled, that random people come to the home. When Mr. Kaziaka brought your daughter back to retrieve an eye patch, he came in and there was a couple in your bedroom, in your bed, in states of undress. That CPS advised him to not return the children to your care, that they've come to your home on numerous occasions and they believe you're inside and refusing to open the door to talk to them. And he also asserts that he has not heard from you, nor have the children heard from you for the last month since he has not returned them. So this is your opportunity to respond to all those allegations and what you'd like to see happen with the placement of the children or their custody.
Okay, Your Honor. I would never let somebody be undressed in any manner from the waist down around my 11-year-old daughter. Nor any.
Well, I think the issue is that you not purposely do that, but you're not being diligent in monitoring your home.
Your
Do you
Honor,
think that you don't think that's not so when he says your daughter walked out and a man was pleasuring himself on the couch, and another incident where a man was walking around with nothing on from the waist down, Mr. Kaziak is just making all that up to come to court and cause problems?
I can justify on that. I do have a roommate, and he was sleeping, and I was actually there the night my daughter mentioned this incident, because we were leaving to go, I believe, get groceries or something. He was sleeping, and I think it was about 8:39, and I said, we'll go grab, some ice cream, snacks, things like that. And he was almost like in a stance, like where sometimes gentlemen, like Al Bundy, like sleeping. He would never do any type of sexual pleasuring around a child. I've been friends with him for many years.
I think these are two different individuals we're talking about. Mr. Kaziak, you want to add in there? This is a different. Gentleman from the waist down is a different.
It's the same person.
Oh, it is the same.
Yeah.
And what's the name of that individual?
Dale Von Yorks.
Correct.
Okay. So, ma'am, did he get up naked from the waist down?
No, he has
accidentally expose himself?
No, absolutely not. I've been friends with him for many years, and I've never even seen him undressed in a manner that made me in any way uncomfortable. He's a very good friend of mine.
So who's not telling the truth, Mr. Kaziaka or your daughter?
I think that, Your Honor, in my opinion, that it is a misunderstanding, a miscommunication, and maybe possibly just drawn out and exaggerated in a sense. Not having I'm trying to put it into words, substantial like proof that something like that happened. I would not be friends with somebody who I would have a concern about
So,
something.
well, so if he accidentally got up and your daughter saw him in underwear and he wasn't totally undressed, what about pleasuring himself on the sofa in front of her?
Absolutely not. Like I said, Your Honor, I have.
How are you sure? So that means either Mr. Keziaka made this up or your daughter made it up. Who are you alleging made it up?
I don't have a definite answer for that, but I do know that I definitely keep a good observation of my household and what is deemed appropriate around my children. I love my children.
Who all lives in your home?
I live in my home with me and my children and my roommate, Dale Van York. And I did also have company come in due to the loss in our family. To help me.
So do you have a boyfriend living there as well?
No, I do not.
What about the allegation? Okay. What about the allegation of the physical fight where people restrained your boyfriend and your daughter got involved and he hit your daughter and she hit him with a broom?
Okay, I can also explain on that, Your Honor. My daughter is, per se, not to make light of it, a little bit of a tomboy. She grew up with two older brothers, and she loves to kind of horse around, rough play, be silly. And what happens usually, in even with her brothers, somebody always gets bumped or hurt or fall, And never would I ever allow somebody to come at her in a manner that would, harm her, because I give birth to her and I would protect her.
So what happened to your boyfriend? How long have you been broken up? When did he depart the residence?
I would say within the last week or two.
Okay. And so do you know that Mr. Keziaka came back to the house to retrieve stuff from your daughter and you were sleeping the whole time and never woke up the whole time they were there?
My kids are okay for a small amount of time if I need to nap. I am a busy mother, always having a lot.
What do you do for work?
I do like DoorDash. I help out. I do house cleaning.
Okay.
I help take care of my father who had a stroke and he's like basically almost blind.
So Mr. Keziaka, when was the date that you took your daughter back home and Miss Keziaka was sleeping and the film was made?
17th, I want to say.
Of July?
Yeah.
And did you enter the home with your daughter to help her, or she took that?
No, the video was from 2 weeks prior.
And who made the video?
Parenting time exchange. Yeah, that was during a parenting time exchange. The incident when he came back.
So you came at a parenting time exchange and she was sleeping in the house and you entered and she didn't wake up the whole time.
Correct.
And guys, I haven't watched the video. I generally do not watch proposed evidence until proper foundation's laid and it's been reviewed. And if you've also sent a copy of that video to the party, otherwise, just so you know, I've not watched it. So I'm describing what you've indicated, but I have not watched that video. And so, sir, you came in, you took the video, and mom was sleeping the whole time in the bedroom.
Correct.
Okay.
May I ask who let him in, and is that something that is usable in court as far as like for my Privacy Act for somebody to come in and videotape you?
So just so you guys know, I'm the court. I respond to evidence. I don't give legal advice as to what that is, but I take it your your son who's 16 and your daughter 11, they let that in. They let the dad in. Have you had a history of letting him in the house? Do you have an open relationship good enough that he comes over with the kids and you guys enter into each other's homes or no?
I don't go in his house. He doesn't.
Just for the record,
Mr. Keziaka, what is
just for the record, Your Honor? He's standing in the doorway. His son let him in. He's standing in the doorway. He's not roaming around the trailer. He's at the entryway.
Okay, I gotcha. Well, thanks for clarifying. So, Ms. Keziaka, what is the name of the CPS worker that's assigned to this case?
It's
Right now it is. Lauren Garcia.
People, and this goes for everybody. This goes for Consul, Mr. Kaziaka. Everybody in court wants to get everything out, but you got to take your turn. So let him just finish this phone number, and then I'll get to your question. Go ahead, Mr. Kaziaka.
586.
And when I was supposed to get my kids on my parenting time, and he said that he did not have any info on a worker nor any phone numbers for me to be able to contact them.
I did not have
Well,
them.
did you call? Did you call Child Protective Services and say, I understand there's an investigation open? Who's assigned to it, and what have you advised? My children's father says he's been advised not to let me see them. Did you call anyone at Child Protective Services?
No, because I had no idea of who my worker was or what.
Have you Okay. Well, no, you call and say, this is my name. If you have an open case, it'll be under your name. Okay. So what is your response? So Mr. Kaziaka says you have not attempted to talk to him or the children for a month. Is that true?
Well, it was under my understanding that he said I was legally not allowed to basically interact with my children. And he's done this before. And last time the judge said he had no right to take my kids from me.
Did you? Okay, just a second. So if you've been through this in the court before, you know you have a parenting time enforcement officer. Are you aware of that? A parenting time enforcement attorney at the front of the court?
Vaguely, Your Honor, but I don't know what the conditions of that would be.
The thing is, you never called anyone to say, hey, my ex is keeping my children from me and not letting me see them. Did you call anyone and make a complaint at the front of the court to anyone claiming he's not giving you the kids back?
No, unfortunately, I didn't, Your Honor, because I was educated as to what the protocol should be. Like that would have been the right thing to do.
But didn't you previously litigate custody before the court? And you just indicated you've been through this before and were in front of Judge Witowski, and therefore I would have thought you would know how it works, right?
Last time I went through this, I also was able to afford an attorney. But due to the burials, and I lost my mom, my brother, I lost my dad in November. I've been doing everything on my own. I'm treading water, just trying to make ends meet. And
I'm going to ask a very blunt question. This is based on the allegations before the court. If I ordered both you and Mr. Kaziak, I'll order him too, to go get a 9-panel drug test immediately. What's that going to tell me? Is it going to come back positive or anything, or no?
I have proven my sobriety in a hair follicle screening already.
When?
In the last
When?
The last time we went.
When was that?
2 years ago.
Yeah, it's just I feel like how many times do I have to prove myself without feeling like I'm being targeted?
So Mr. Kaziak and his attorney are going to correct me if I'm wrong, but before you appeared on the record 40 minutes late, he said he's familiar with how you appear when you're under the influence, and he said that to him your appearance is indicative to how in the past you look when you're using.
Oh, okay. Well, Your Honor, he also demeans me to my children constantly. And like when I go to pick them up, he will tell me either I look fat or I look too skinny, or he's constantly trying to break me down emotionally and mentally. And through all the years of abuse he put me through, I have a lot of trauma from that. So I'm very timid.
Your Honor, this is deflection at its finest, and she didn't even answer your question.
Stop. I don't need her to be corrected, counsel. I've done this a long time. So, ma'am, have you tried to contact your 16-year-old son on his cell phone in the last month?
He did text me happy birthday, and I did text him and ask him kind of, like I was really sad what was going on, and he stated that he did not really want to talk too much about it because he didn't want to get in trouble with his father.
But why not call him and talk to him verbally or text him? Why not? He's a 16-year-old. Why not contact him?
Because throughout our marriage and everything, my ex-husband, he was very controlling. It's always been his way or no way. I give him leeway if he needs an extra day. Like the day I was supposed to pick up my kids, I gave him an extra day to take them to the fireworks with no problem. And then the day I go to pick them up, he says, "Oh, well, a case was open yesterday." Well, why wouldn't you inform me? So it's almost like he's just always trying to reach in a basket of, a hat of rabbits, trying to pull something out when I'm doing my best. And
Okay.
I'm always trying to co-parent at a civil manner with him to save you and the court's time and us time. I'm doing my best. He's doing his best. And a lot of things I'm sure you're aware of can be handled without going through all this.
Okay.
I won't
And
admit.
so let me do this. Let me confirm. So you've confirmed your phone number. You want to confirm an email address for us and your current address so we make sure you have all the information. Address, ma'am. What city do you live in?
Yes, right. Move forward in life. It's just
Okay.
as a single mother and with the economy, it's hard. And I just asking that you see that some of us struggle at times, from time to time in life, especially trying to make ends meet and bills, and especially when you're a separated family.
Okay. And sir, what city do you live in? How far are you guys apart from each other residence wise?
Right now, it's about 10-15 minute drive.
Okay, so you guys are close.
I do most of the driving, Your Honor. I'll drive my son to school, come back home
On her
for my daughter
days.
to get a little more rest, and then I got to drive her to school and come back, and then in the afternoon I have to do 2 more rounds, so it's 8 trips.
Your Honor, the children are enrolled in Rochester School District, which is where my client lives. And just for clarification, I want to make sure her email was amandak0813@gmail.com.
Do more driving, but those are on her parenting days. It's because she'll drive back and forth to her house twice to drop them off at school and then go back home and then take the other one to drop the other one off, so it's.
And Jason, can I also bring it to the attention of the judge that when we went through this last time, you would not allow me to speak with the children?
Your Honor, they don't need to dialogue with each other. Just for the record, again, you asked her a specific question. If she were to submit to a 7-panel drug screen, what would show up? And she has not provided you an answer to that question.
Well, she said she took a test before, but ma'am, do you want to answer that? Will it be clean? Because
2 years ago.
Guys, stop. I can count, counsel, with all due respect.
I feel, Your Honor, it's humiliating and it's degrading.
Well, guess what? He's going to do it too. But when parties tell me that the other party's under the influence and they witness their appearance, then if it comes back clean for both of you, then you can say, see, he's wrong and he's not being honest to the court. And that can support you. But you guys are both going to submit to your 9-panel urinalysis drug test today at a JAMS location with the results being provided to each other. I'm going to add a protective order that, guys, you don't post this stuff on social media. You don't give it to family and friends. You are both parents of these children. If either one of you is using, that doesn't change the fact that children love their parents and you love them. So I'm going to add in here that both parties shall submit to 9-panel urinalysis drug tests at a JAMS location within the next 12 hours, with the results being provided, ma'am, to plaintiff's counsel. And sir, your results, you can give them to counsel and he can send them to Ms. Kaziaka.
Your Honor,
just so you guys know, any dilution element is viewed as a positive. And ma'am, you had a question?
Yeah, I am in the process of scheduling funeral arrangements today for my aunt, and I'm watching over my nephew because he's very young and he lost his dad. And I'm just wondering if we can do that for tomorrow.
Okay, so with all due respect, so you just were out of town for 3 funerals and now you have a 4th funeral all within the last 30 days?
I had 4 deaths in yeah, absolutely.
What is the cause of these passing away, if I may ask? All these deaths?
My friend, he was found assaulted intimately, sexually. My uncle passed away of natural cause, I believe, due to diabetes. And my sister-in-law Jason hasn't told me what she passed from.
That was a month and a half ago.
And my aunt passed away of basic old age.
I'm sorry, I didn't hear.
Just basic
Like your aunt.
old age, basically.
Okay. All right. I'm sorry
But
for
it's
your
just been a lot
losses.
of
I will say within 24 hours instead of 12. Instead of 11 tomorrow morning.
Your Honor, wouldn't hair follicle be better than your analysis?
Well, guys, your analysis is 20 to $30 and hair follicle is probably far more expensive. So right now I'm going to do your analysis.
Your analysis would not go back as far.
Your Honor,
I care about you right now.
follicle.
Guys, stop. Guys, stop. Ma'am, 2 years ago doesn't matter.
I know,
You
but
can be
it's
clean and
just, I feel
sober.
like,
With all due respect, stop. With all due respect, either one of you, anyone who in the past has had a history of use of abusing alcohol or drugs can be clean and sober for a while, and then they can fall off the wagon, unfortunately. So 2 years is too long ago. This will assist you just as much as if you come up clean, then you can say, listen, I'm clean. But based on the testimony presented and what's going on, I think it's both parties should submit. Guys, they're $20 nowadays, $20-$30 for your analysis. And there's JAMS locations all over the place. So Google JAMS locations, and they're all over the metro area. That's why I used JAMS. And there's a whole bunch of them. And they're also used by some of the district courts as well. All right, so I'm going to make a recommendation, guys. I have other motions. I got to get moving here. We've now used up an hour, and I have other motions that I got to get to. So my recommendation is as follows. One, based on the testimony presented, the children should remain. And ma'am, you know that the judge entered an ex parte order on August 1st, placing the children of Mr. Kaziaka. Are you aware of that?
yeah, I
Did you
read
get a
that in
copy
the
of that?
paperwork. I just didn't
Okay.
understand why, like,
Well, but because there's a lot of serious allegations going on here, one of which is that your significant other hit your daughter and that there's men in undress in front of an 11-year-old girl. There are serious allegations here.
and did he also bring up that he also had hit my daughter and she told her school right before she got out of school?
How long ago was that, you allege?
A couple of months ago.
We have
That she
So,
went,
Mr. Kaziaki, you want to?
I can respond.
Mr. Kaziaki, you want to respond?
The minor child had a bruise on her leg from falling near a pool, and Miss Kaziaka told Mr. Kaziaka, and I believe we even have verification, that she was going to try to use this against him if he were to bring her back to court and allege
that's a
abuse
different,
falsely.
that's a different incident.
Okay, so guys, guess what? I'm going to send you guys for investigation and recommendation, and you guys can tell the investigator all the above, all my social worker at the court, all of these things, and they will investigate them. I'm going to include that investigation shall include a home visit of defendant's residence. All right. So again, one, based on the minor children should be remain temporarily placed in the care of plaintiff father. Two, defendant mother is awarded Ma'am, if someone is going to supervise your parenting time, is there anyone that you would recommend or propose to Mr. Kaziaka be the supervisor?
My father.
And sir, your response to that?
I don't talk with her father, and I haven't for a very long time. So I would.
Well,
I don't think I'd be comfortable with it because he wouldn't be.
He's a very respectable Catholic man.
The supervision should
Ma'am,
be
do you
done
know
by
Mr. Kaziaka's father?
Yeah, absolutely, and I would trust him as I
How do you get along
hope
with-
that he would trust my father. My father has always been very good to Jason.
And Mr. Kaziak, any response to that her dad's been a responsible guy that you've never had an issue with?
Judge, she just indicated she respects and trusts Mr. Kaziaka's father. There's no reason he can't.
I heard, guys, I heard.
I deserve this.
I don't disagree with that. I'm just looking for alternatives.
I don't. I haven't
Mr.
talked to him in
Kaziaka.
years. And when I tried to reach out to him last time when we were going through something similar, I got no back feed from him at all. So it wasn't like, because I was trying to work with her to get things solved for the children last time too. So, but
Let me ask this. Do either one of you practice religion or go to church on Sundays?
Yes, Your Honor.
You both? Okay. So you're in church at noon? Because I was going to give you parenting time on Sundays from noon to 5 or 4.
For me,
Yep.
I miss my children very much. So I'm sure that I can discuss that with the Lord above, that I really would like to see my children and we could pray.
Okay. All right. All right. So on a temporary basis, defendant should be awarded parenting time on Sundays from noon to 5 p.m. to be supervised by plaintiff's father or another mutually agreed upon third party.
By whose father, Your Honor?
His father. And what's your father's first name, Mr. Kaziaka? Remind me.
Dwayne.
Dwayne. Plaintiff's father, Dwayne. All right. The matters of custody and parenting time are referred to the front of the court for investigation and recommendation to include a home visit. Following the issuance of a custody and parenting time recommendation in this matter, the matters of custody, parenting time, and child support should be referred to the front of the court for referee evidentiary hearing. And child support should be suspended pending further order of the court. So guys, I am a referee, not a judge. So, well, they'll work it out with the supervisor.
Can I have
So
one
guys-
more question, Your Honor?
Yeah.
Would it be possible to rotate the parenting time so in the comfort of with his family and my family, so my kids can see my father?
Well, you guys talk about mutually agreed upon third parties. If you don't agree, so guys, I'm a referee, not a judge. You both have 21 days to object to my decision. These are very contested issues and subjective to mine and the judge's views. We do not always agree. The judge is the boss of the case. She is the final say. So if either one of you do not like this order, I'm going to email it to you with the objection procedure. I suggest you object within the next 21 days and get a hearing before the Honorable Terry Lynn Dennings, and the judge's decision trumps mine. She can overrule me, and her decision's the final say. So if either one of you does not like all or part of my recommendation, you are welcome to object. It is your right under the law. I don't get mad. She doesn't get mad. And the judge will decide if she wants to uphold my order or change all or part of it. And when you get that order in the objection procedure, if you have any confusion on how to object procedurally, you are welcome to call my staff and they will help you through the objection procedure. They can't tell you what to write on the order. They can't give legal advice, but they can help you procedurally to make sure that your objection gets filed and a hearing gets scheduled before the judge. So you will get those. And is everybody okay getting this stuff via email?
Yes.
Ma'am, are you okay with email?
Yes, Your Honor.
You'll get it right away this morning. All right. I also, as I indicated, ordering within 24 hours, you both submit to 9-panel urinalysis drug tests at your own expense, with these results being exchanged to each other. You may not post these results on social media or provide them to individuals unassociated with this litigation. Okay. All right, guys, you have 21 days to object. That's going to conclude this hearing. Please have a good day. Stay healthy and safe. And if you don't get this order by the